Hello, I'm Craig Purshouse. I'm an Associate Professor here in the Faculty of Law, and I'm also Deputy Director of the Centre for Private Law and Deputy Director of the Centre for Medical Law and Ethics. I studied law at the University of Sheffield as an undergraduate and then did my Masters in Healthcare Ethics and Law at the University of Manchester, and then I continued there for my PhD. I was a legal academic in the UK for almost 10 years, most recently at the University of Liverpool before coming to Hong Kong. My research interests are in torts and medical law and the interaction between the two, so often medical negligence. I'd always lived in the UK, and so I was ready for a change of experience. I really loved Hong Kong when I visited the city in 2018. And HKU has a great reputation, both for world-leading academics and for excellent students. So this was a real attraction to me. Also, it has key strengths both in medical law and in private law. And given my research interest, this was very attractive. Moving to Hong Kong has influenced my work. So when I was in the UK, I was still interested in common law decisions in other parts of the world, but moving to Hong Kong has meant I've internationalized my research much more, not just with the law in Hong Kong, but other common law jurisdictions such as Singapore, Australia, and Canada. So I'm very interested in how the questions I'm answering are dealt with across these common law jurisdictions. So I think this was a great move for me, and I'm very happy here at HKU. A number of things actually led to me specialising in these areas. A key one was I actually had some experience of medical negligence when I was a teenager, so that made me very interested in these issues around medical negligence and the balance between the rights of patients and the interests of doctors. So I find this a very interesting topic anyway. And I had a number of mentors both at Sheffield and Manchester who helped me. I won't name them because I'm worried that I might miss some names off. I would say there's a number of remarkable similarities between legal education in Hong Kong and in the UK. Differences, I think HKU offers a lot more double degrees, and the common courses here give it some similarities with a liberal arts degree in the United States, whereas the UK legal education tends to mainly just focus on the law. So I'd say that's a key difference. In terms of student expectations, they are very similar, but if I was to make a generalization, I would say students in Hong Kong are very ambitious and very hardworking. So that makes it very refreshing to teach people who are excited about the subject. I would say to students, work hard in your studies. A higher GPA will open a lot of doors, and if you're interested in researching medical law and torts, it's a good idea to undertake a dissertation or a guided research project in this subject. This will give you some practice of legal writing to a higher level. I also think it's good to start publishing early. Case commentary or a book review is a good idea if you're just starting out to get used to academic publishing. I also think once you actually get started with legal writing, it's a good idea to send your work to several people to get feedback before you send it out for publication. They might spot errors which will prevent it getting rejected by a peer reviewer on those grounds. And also make sure you carefully target the journals. Make sure your piece is a good fit and you're following the guidance that they suggest. If they only accept papers of 10,000 words, don't submit something of 15,000 words, as it will just immediately get rejected. So think carefully about where you are publishing the work. So my current research is on claims for psychiatric injuries in negligence. Where somebody suffers a psychiatric injury as a result of witnessing another person being killed, injured or endangered, the courts have placed a number of restrictions on this type of claim. And this has often been criticised by academics. So what has tended to happen is the courts have introduced restrictions, academics have criticised them, and then the courts, when the next case comes, have chosen to keep the restrictions. The academics then criticise this, and it seems to be going around in circles, the debate. My new research is aiming to move past these debates to look at whether these rules do actually have a principled basis or not. So I've written one piece on this issue, and I'm hoping to expand this into a bigger project, but it fits within the work of the Centre for Private Law, it being on tort law, and also the Centre for Medical Ethics and Law, given the medical issues surrounding mental health. I would say they do. Health is of fundamental importance to everyone on earth. And the core values of medical law, things like patient autonomy, confidentiality, avoiding harming people, improving people's health, these are important everywhere in the world. However, I would say that application does differ in different parts of the world. The balance between these values might differ, and law is always local, so the application in different legal systems is often different. For example, here in Hong Kong, there's a greater use of traditional Chinese medicine than there is in the West. So a lot of cases in Hong Kong involve this type of medicine, whereas in the West there's a lot more cases on orthodox medicine. Also, different cultural values might come into play. For example, Confucianism might mean that situations where children disagree with parents and doctors over their medical treatment, there's less likely to be litigation in a society that follows Confucianist principles than one that focuses more on autonomy. However, having said that, there are these differences, but I would avoid any reductive binaries on this. In the classroom here in Hong Kong, there's a variety of different student views on any issues that we cover. So while there are different local applications and different levels of emphasis, I would agree that those core values are the same across the world. I'm always most excited about whatever I'm researching at the moment. So at the moment, I'm very interested in issues relating to psychiatric injuries and mental health, and also reproductive negligence. However, on the issue of trends, I think with research, sometimes I have researched on topics that might be seen as trendy. So I did research on surrogacy and conversion therapy when these were issues where there was going to be law reform in the UK. However, I would say academic research does take a long time to complete. So if you always follow the trend, by the time you've written your piece and it's gone through the peer review process, it may no longer be trendy anymore. So I do try to keep track of the trends, but I mainly research on what I'm most interested in. So with the issue of AI, I think there are very significant challenges that it it poses. There are issues of regulatory capture by AI companies. It could have obviously great beneficial consequences, but also there's the potential for harm. However, in my specific research of tort law, I think that it is quite well equipped to deal with the issues of AI. This is because tort law is very flexible and changes over time. So while AI does pose great challenges, we have to remember that AI is seen as part of the fourth industrial revolution. Tort law has therefore managed to handle the three previous industrial revolutions quite well. So while I think there will be amendments in response to AI, I think many of the broad principles, don't carelessly cause injuries to other people, being a key one for negligence, will still be of salient. Yep. So prenatal injuries, it's best to illustrate this with an example. So there was a drug called thalidomide which caused birth defects when taken by pregnant women. So women who'd taken this drug, their children would be born with quite serious disabilities. This, if they were to claim this, would it be a case of prenatal injuries? The child would have been born healthy, but now it has a disability caused by the drug. Wrongful life cases are slightly different, and I'll explain why. In a wrongful life case, an example might be, let's say a woman is pregnant and she's contracted a disease such as rubella, which can also cause birth defects. But contracting that rubella was nobody's fault, so there's no negligence at that stage. Let us say she goes to see a doctor and the doctor says she doesn't have this disease. She then gives birth to the child and the child is born with disabilities as a result. However, if the doctor had told her you have rubella, she would have had an abortion. So the child would not exist. If that child brings the claim, it's not the same as the thalidomide case where the child would have been born without a disability and now has a disability due to somebody's negligence. Instead, the child would either be born with the disability due to the disease, which was nobody's fault, or if the doctor hadn't acted negligently, the mother would have terminated the pregnancy and the child wouldn't exist at all. So these are quite controversial claims because the child is arguing, I shouldn't have been born or I shouldn't exist. So the difficulty with these cases is saying, can existence be a form of damage or harm? Now, in my research, I looked at the legislation governing this, and it's the same legislation in England as it is in Hong Kong. And I found a number of inconsistencies with this legislation. So whether people support these claims or don't like these claims, they are very controversial. The legislation in this area ends up pleasing nobody because it's so inconsistent. So I argued for ways we might amend this legislation to come up with a more principled and coherent approach. This is a very controversial question across the world. First, we have to understand what we mean by a right to die or euthanasia, because these can sometimes be seen as vague terms. People might mean by a right to die the right to refuse all medical treatment, or they might mean somebody taking active steps to help you die, so the involvement of another person. Similarly with euthanasia, sometimes people referring to voluntary euthanasia, where somebody's choosing to end their life. Sometimes they're referring to ending somebody's life where they haven't necessarily agreed to this in order to end somebody's suffering. So it's controversial to first decide what we mean by these terms. Then there's a second controversial question: should we allow these practices? This is often ethically controversial because we have to balance somebody's right to decide how they live or end their life, together with issues of reducing suffering, but also issues of protecting vulnerable people. And also suicide has an impact on people such as the person's family, not just the person ending their own life. So these are all complex factors to take into account. And then there's another question of, is this best left to the courts or to the legislature? So there's a political or constitutional question at play. Now, with this issue, it's one where I love the debates in the classroom on this topic. You often find a variety of different views, and I find the differences in views in different jurisdictions very interesting. But the thing I've found is, both in the UK and here in Hong Kong, where we do have a lot of students from the mainland in the classroom, there's a huge diverse range of views in both jurisdictions. So it's definitely not a question that I have a solid answer to. I have my own views on this, but that they would be the factors that I think should be taken into account. This is a difficult question to answer. There's a phrase, man makes plans and God laughs. So if we try and predict the future, it can be quite foolish. However, that said, I do think AI will have a part to play in legal education in the future. It does provide some benefits, but there are also a lot of costs. We have to make sure that the work is the students' own work and that they have the abilities to both use AI effectively, but also to be able to answer legal questions and analyze problems without the use of AI. No client is going to want to go to a solicitor or barrister who has to consult ChatGPT for every question that they are asked. So we need to ensure that students are developing those skills of analysis, being able to read complex judgments without assistance. So I think this is going to be a key challenge for legal education in the future, together with ensuring examinations involve the student's own work and not just the work of AI. But legal education is often influenced by the legal profession, and changes in the legal profession often filter through to legal education. So it's hard to predict what might happen in the future, but they would be my tentative guesses. However, I do hope that there will still be a future for the traditional lecture and tutorial format. They've lasted for centuries, and I think they will still have a place in the future too. My question for the next interviewee would be, do you have a writing routine when you conduct your research? Yeah, so I read a lot of history books. So in the UK, I would be reading about the War of the Roses and the Tudors. More recently, I've been reading lots of books on Chinese history, but I'm going to recommend 3 novels. I'm going to go with Ishiguro's The Remains of the Day, Margaret Atwood's Cat's Eye, and The Bone Clocks by David Mitchell. With films, I go to the cinema quite a lot, so this is hard for me to choose 3. I'm going to go with Working Girl, Blue Velvet, and a Chinese film I saw recently called Farewell My Concubine.